February 24th, yet on the morning of February 27th,
Mover Nation, Alex Murdaugh is back in court again. Dick Harpootlian arguing.
The hearing we were all present at.
This has been going on for a while. I've been watching it, but I was trying to see if I could live stream it. Sometimes there are issues with live streaming.
She was talking about the case, and she didn't think he was guilty.
No.
That Facebook page had never been produced, and then she produced a Facebook posting, she said, by the egg waiting's husband. Turns out to be a guy I interviewed in Georgia, apologizing for what he had posted on Friday night, which concerned his wife's aunt meddling in their marriage. I think that's fertile ground for cross-examination. Your Honor may disagree with me, but I still would like to put those items into evidence for the appellate record at the time. The last thing I would say is this. In terms of Your Honor questioning the jurors, we need instructions from you as to whether you want, after you finish with the juror, do you want us to submit questions to you? I doubt you're going to let us question them. How is that process going to work? And will that be done someplace? Will it be done in this courtroom? Will it be done somewhere else? And if the jurors are going to be questioned outside of this courtroom, will there be a way for the public to hear what they have to say? Thank you for your indulgence.
Very interesting. So this is Justice Jean Toal is listening. I've been listening to this privately, and I was like, oh, and by the way, can you guys hear the audio? Because sometimes these live stream plays of actual streams of the court do not work properly, which is what I was trying to sort out. So give me a heads up if that works.
Rightly points out, it's not just what they heard, may have heard from the clerk, but is any of the other jurors, for instance, Egg Lady, we keep calling her.
Egg Lady.
Gave an affidavit indicating Becky said things like, don't be fooled, watch the body language, watch body language testifies to Mr. Murdaugh. Did she relay that to any other jurors? It's not just what, I mean, was it, did it, or did...
So this is at the crux of their argument for a retrial motion with the evidence against Becky Hill, which, as you guys know, I'm very interested in, as you know.
Sitting juror or the alternate in the
So Murdaugh had his glasses on earlier. Obviously, he doesn't need his glasses now. Maybe he got LASIK in prison. Just kidding. We heard from Creighton Waters earlier. He was presenting the prosecution side. It seemed that Judge Toal felt that
in the memorandum of interview, now the Clerk's private lawyer, Mr. Lewis, objected to any videotaping or audio taping of the Clerk when she was interviewed. But in the memorandum of interview, she, that is, the Clerk, indicated she had conversations with the four-lady outside the presence of the rest of the jury about what was going on in the jury room. Obviously, I would cross-examine her on that, but it may be necessary if she testifies to things that are inconsistent in that MOI for us to call the sweat agent that did the interview to corroborate the MOI. The MOI may be introducible in and of itself as an exception to the hearsay rule, but I believe it may be necessary for us to call the sweat agent. We're not going to, and Your Honor, we're not, you've indicated that you're not going to want any sort of summaries of those interviews by the jurors when we talk back in chambers, or necessarily the MOIs. You want your own fact-finding with the jurors. To the extent that they contradict those, we may put all of that into the record for appellate purposes. And if you want to see those before you have this hearing, we obviously put those. We can put those in the record today, or have those available to you, both the MOIs and the videos. Or, I mean, we're obviously we're going to do whatever you tell us to do, but we're looking for some guides as to if there's anything we can get you prior to that evidentiary hearing concerning those memorandum of interview by the SWED agents and the videotapes. Whatever you.
Just gonna catch up with my reading while this is going on.
Mentioned, and Mr. Griffin reiterated to me just now, and obviously you don't need to tell us this today because we're not going to be doing the questioning, but there is the consideration of 606B and the incursion into deliberations. At some point, we don't need to know that today, but at some point prior to your questioning the jurors, we'd like you to enunciate what your position is on that.
You're going to have to outline that a little bit more for me. What part of 606B are you discussing?
Well, it says, if I can find my glasses. Upon an inquiry into the validity
You should get
of the
LASIK.
indictment, a juror may not testify as to any matter or statement occurring during the course of the jury's deliberations or to the effect of anything upon that or any other juror's mind as or emotions as influence a juror to assent to or dissent from the verdict.
All right, Sam, what are you saying that imports for this proceeding?
Well, I mean, for instance, if we show you, we prove to you that the court said, do not be fooled, or, you know, watch Murdaugh's testimony, watch the body language inferring he was lying, he will be lying. One of the issues is if the juror who sat during the deliberations and said that the court said that, did she discuss that with any other jurors? Did she infect the jury? Does this allow you to do that?
Well, you certainly, if you go to 606B, it gives you some guidance about that. It says, upon inquiry into the validity of a verdict or indictment, a juror may not testify as to any matter or statement occurring during the course of the jury's deliberations or to the effect of anything upon that or any other juror's mind or emotions influencing the juror to assent or dissent from the verdict or indictment or concerning the juror's mental processes, except a juror may testify on the question whether extraneous, prejudicial information was improperly brought to the jury's attention, or whether any outside influence was improperly brought to bear upon any juror. Nor may a juror's affidavit or evidence of any statement by the juror concerning a matter about which juror would be precluded from testifying be received for these purposes. I take that to give us the guidance we need about the parameters of the questions.
But if, again, if the juror that gave us the affidavit, would she be asked, did you discuss that during deliberations? Did she do that?
Well, that apparently is very questionable under the terms of 606.
Yes, ma'am.
And I intend to abide by that. The way those questions have been asked in many cases I have reviewed is to ask the juror whether that's still their verdict. If they're asked about improper contacts and they talk about improper contacts, then the way to pursue it beyond that for the judge is to ask about the impact on the verdict, not on the deliberations themselves. That may be a small slice of difference, but I think it's very important to understand that no one, not myself or anyone else, is going to be asking the juror about the specifics of their deliberation, and the rule is quite clear about that.
Okay. And is it clear that you will not be using the SLED interviews or MOIs to attempt to impeach.
I told you when that was brought to my attention in our Chamber's conference this morning, I haven't made my mind up about that. I don't know what's in those summaries or anything else, and we're going to have to discuss that. But again, I'm the one doing questioning at this point, Mr. Hartwig.
Yes, yes.
And I'm trying to perceive what you all are asking, and I'm going to go to the state now and see what their reaction is to what you said.
Thank you, Your Honor.
Mr. Waters?
Thank you, Your Honor. May it please the court. Your Honor, again, we would concur with what Your Honor just said about Rule 606 and, of course, all the cases that we've talked about, and the need to show prejudice. And obviously, when you're talking about external influence, that prejudice, which will be an appropriate subject of inquiry to the jurors, is whether or not there was an impact on the verdict. And we, of course, have suggested to Your Honor, not only based on the cases, that should be judicially conducted in a manner that protects the privacy of those jurors and it protects the privacy of their identities. These jurors, were drafted into service, and this inquiry, of course, has to happen, but it needs to be conducted in a manner that respects their privacy and should be, of course, judicially conducted. We have suggested those two questions. If we look at the Bryant case specifically talked about the fact that depending on how the examination goes, there could be questions suggested by the parties. And obviously, I think we would need to cross that bridge if and when that bridge needs to be crossed. And that starts with the court's inquiry to those jurors, and only if something arises that needs further inquiry could that be addressed at that point. And that could be even a discussion from counsel with the court as to what additional questions may be proper.
He definitely looks very confident in what he's saying. And I don't know. Again, I'm not a lawyer. I am not law enforcement. I'm not a psychologist. I'm just a guy who's been through a lot of shit. But let me tell you something. I don't know how this is going for Team Murdaugh, because they're trying to, they want to get a retrial. That's what they want. But it seems that Judge Toal, from everything I've been watching so far, is leaning more towards the state.
When the state first became aware of these allegations, the first thing that we did was have SLED do an independent investigation, and the goal was, good, bad, or ugly, to get to the bottom of what, if anything, happened. And the result of that is why we're still here today. And that is that in speaking with the jurors that spoke to us, that the balance of the evidence, as well as in talking to the clerk staff, was that there was no impact on any verdict. There was nothing unprofessional or untoward that happened that had any effect on the verdict. And so when we did that inquiry, and that is what the jurors said, that is why we're here today, and that's what this hearing is going to address. The only juror that we have is the one who filed the affidavit. That's 630, and even she, or that person, only said that she, eventually voted guilty because she felt pressured by the other jurors. Did not even mention any external impact. And so unless she's going to change her story, that is what was in her affidavit. So the balance of the evidence is the reason why we're here today, and why this hearing needs to take place. Your Honor, as far as inquiry to those jurors, again, there could be a need that the parties would suggest questions, and it could be, depending on how things go, that the affidavits or maybe even the recordings, all of which have been provided to the defense, the full recordings of those interviews of any potential witness in this case have been provided to the defense. It could be that issues could arise from either the state or the defense as to impeachment. And we can address issues as they arise under the appropriate rules, 608, 613, and the like, dealing with not only prior inconsistent statements, but other evidence that would be properly impeachable. Ultimately, I do need this contention that somehow the clerk is a party opponent in this particular case, and we believe that that is.
I was going to try to read the defense's brief that they submitted to the court for all these particular jurors, but it won't let me do it in the same box. Oh well. Thank you so much, Wishful Making, for the super sticker. I'm gonna let this play for you all.
Incorrect. Obviously, there is a hearsay exception or a non-hearsay determination in the evidentiary rules, I believe in 801, that excludes statements of a party opponent. But just because the clerk is an elected official and of the state, that does not make them a party opponent in the way that term is defined. A party opponent is an active litigant before the case. and that is, I think, different. So we would certainly say that the hearsay rules would still be in effect as it relates to Ms. Hill and any testimony that she may provide. I know there's been some discussion about the order in which the witnesses may be called and whether or not Ms. Hill would be a hostile witness. And obviously that's under Rule 611 and I believe C, which will allow leading questions, if a person is hostile. I think, again, at this point, I don't know that any showing necessarily has been made, but I understand the defense may raise that point and we may have some arguments at that time. But I don't know that there's been such an identification between Ms. Hill and the state that would allow, her to be identified as a party. I think that's far out of bounds, but also that she would be applicable to allow defense leading questions under 611C. Your Honor, in looking at the type of examination that would need to happen here, and again, the issue also arose of the Fifth Amendment. And I know that the defense would like to brief that issue, and we're happy to respond. We don't know exactly how that might arise in the course of any examination. We need to cross that bridge again when we get there. We would say, though, that the Fifth Amendment is question specific, and so again, it may be something that this court has to rule, as is in any sort of evidentiary presentation, question by question, based on any objection by the parties. So it's kind of hard to say that exactly what the blanket position would be until we actually get to that determination. Ultimately, the defense referred to some information provided this morning. Actually, both sides exchanged last night their communications with the clerk during the course of the trial. So both sides did that last night. And there were a lot of communications with the defense as well. And so, again, I just want to point that out that there's any sort of allegation or insinuation that the state's not providing information. We've been very diligent about providing any and all information to the defense. And if any additional information arises, we will continue to do so. But both sides exchanged that last night. And of course, there's been some reference in their filings as to emails that were forwarded from the clerk to me and to my paralegal.
I would agree with that, Debbie Richmond. I would agree. Yeah, she's made several statements. Absolutely, Karen Fan. I was watching this earlier. I didn't think I could stream it because of software limitations. But yeah, here we are.
And they've actually even listed me on the witness list. And Your Honor, as we have had a chance to peruse the defense communications with the clerk, there was
specifically just before this, Judge Toal had said that she didn't think, based on prior case law, that the defense is saying it doesn't matter what the verdict was that they were going to give in the case. That is irrelevant. What they're saying is the fact that they were tampered with in general or communicated with in general. They don't have to say whether or not that affected their verdict. And Judge Toal basically had said earlier, yes, per these other cases, it is relevant that their verdict had been altered, or that they had said they were going to give a different verdict. The defense had argued no. So Karen Fantang has made several statements this morning. Those were some of those statements that she had made earlier, which were pretty much like, whoa, okay, that's serious. All right. Oh my goodness.
Just as much communication and offers of help. It was just a uniform across the board courteousness that's reflected from those. So we think that that's a non-issue, and we think that should not be something that arises during the course of this evidentiary hearing, at least as it would require communication from or testimony from attorneys. Your Honor, ultimately, as we look at the inquiry that will need to be conducted, as the state has made clear, it starts with the jurors. And only if something arises in that inquiry, further inquiry to those jurors may be necessary. And that could be in discussion with the parties, as I've stated before. And then I know Your Honor has indicated the clerk should testify, and we certainly understand that. The clerk filed an affidavit denying any of these allegations. And so, again, as we address the clerk's testimony, the state would have objection to some of the information I believe the defense would propose to examine her on. We believe that an inquiry should be limited to what is appropriate and relevant impeachment, but not should be just a far-ranging fishing expedition or full inquiry into a lot of subjects that have come up since the trial that we believe are not relevant to any point inquiry that is before the court here now. Obviously, rules 404, 401, 402, and 403, as well as, which of course address relevance, and 403 objections, 404, which addresses other crimes or wrongs or acts, Rule 606, or excuse me, 608, which addresses inquiry into other specific acts and impeachment, and Rule 613, which talks about prior inconsistent statements. All of those rules potentially could come into play depending on the nature
There
of the
he
testimony
is.
and the nature of the inquiry.
Big
There
Alec.
have been allegations since the trial about the book, about this wiretapping case, about investigations into alleged use of office for improper gain. But again, all those are subsequent to the trial. And so again, depending on how the testimony goes, the state would raise appropriate objections at that time to limit the inquiry to what is appropriate for what is before the court we would submit, and that is what occurred during the trial. So we would make those particular evidentiary objections as things develop.
Yes, he does look mad.
Ultimately, that would be the state's position. I know that we're trying to put as much meat on the bones as we can at this particular point in time, but I think the reality is that the court's inquiry to the jurors will really determine the nature of the inquiry that needs to proceed from there. And at that point, the state would take the positions that I've outlined here today.
You reply.
Please, the court, Your Honor. 404, I find it somewhat ironic. The state is quoting Rule 404, Your Honor. One of the exceptions to 404, I notice would be surprising to Mr. Waters, is motive, as if he'd never heard that before. He told me this morning one of the assistants that worked for Ms. Hill during this trial was told by Ms. Hill during the trial that a guilty verdict would be good for sales of the book. Motive, selling books. So we believe we should be able to get into that. We should be able to ask Ms. Hill about it, if she denied it, to call that witness, that assistant, and have her testify that she was told that. I mean, why would a clerk do what we allege she did? We think is important for Your Honor in terms of credibility and context. That's number one. Number two, Your Honor, I think we've all agreed you're going to ask the questions, whether we agree or not. And we do agree with that. The question's going to become, as we go through that process, how, if a juror says X and they've said in their interview Y, or if they've said to us Y, or didn't include it in their original affidavit, and you don't ask that question initially, how are you going to handle, or do you care, how we suggest to you a further question? Because, as Your Honor's seen this morning, the back and forth can go on for a while, and we certainly don't want that to go on with a juror. So we're going to need some guidance on that. I'm not expecting that guidance this morning. The last thing is, as these jurors are examined, I need to understand a little bit about the logistics. Are we going to do it in this courtroom? Are we going to do it in another courtroom? Is the public going to be able to hear the responses? Will there be an audio feed if we do it somewhere else? Are you going to have cameras turned? Do it in this courtroom and have cameras turned off? And we're obviously not going to refer to jurors by their names. Even though 3 of these jurors went on the Today Show, another one went on ABC. They were all in the courtroom when the judge had them brought in. They were in the courtroom, all except one of them, for the verdict. Cameras were there then. Again, I'm sensitive to their anonymity, but I don't know that any of them have any real anonymity anymore. Saying that, I think it's important not only for Your Honor to hear their answers, but for the public to hear their answers. Thanks. Thank you.
With respect to the jurors first as witnesses, I will be doing the questioning of the jurors, and I will notify the parties pretty promptly what I intend to ask the jurors. The ambit of what I will be asking them is informed by the question of whether improper contact was made with them and whether it affected their verdict. I understand that you, on the defense side, have views about what further should be asked of jurors on two levels. One, as a predicate to what you want to do with the clerk herself in examining her. And two, as a means of further attacking the credibility of the clerk in her testimony. I have not seen any of the SLED material or memoranda concerning the state's summary of these interviews and so forth.
Oh boy.
We'll be open to receiving that if it's done promptly, because we've got a hearing coming up the 29th, and I want there to be plenty of time to revise any current ideas about who to subpoena, who to call as witnesses, and who has to do that. But I can tell you that I am very, very reluctant to turn this hearing about juror contact into a wholesale exploration of every piece of conduct by the clerk alleged to have been improper on its own, indicative of her characteristics, her personality, or anything of that nature. This is a very focused inquiry that deals with this jury and what impact contact, if any, had on this jury. So I am very mindful of the limited nature of it. As I say, I'm not excluding submission in advance of information that would take the questions beyond the limited questions I've initially indicated. But I will be very hesitant about any of those questions as it involves propounding those questions to the jury. As it involves questions to Ms. Hill similarly, this is not a time to explore every mistake or incorrect statement or false statement that ever has been made by this witness. I am the judge of the credibility of this witness for purposes of this new trial motion. I don't think it's necessary, nor do I think it's proper, to explore each and every impropriety alleged to have been committed by the clerk. At the same time, what specifically should be asked is something that I will look at as I look at the submissions that are made before the hearing takes place about what is requested to be allowed as topics for questioning of the clerk and what exhibits should be used. I can't imagine allowing thousands of emails to be made exhibits in this process. Either emails sent by her to attorneys in the case, to other court officials in the case, or to other individuals during the course of the trial of the case. I certainly will try to preserve the appellate posture of defense in this regard, but I will put certain limitations on just a wholesale exploration of every problematic piece of conduct, ethical, dealings with the county, and so forth. This is a very focused inquiry about this jury and its ability to render the verdict it rendered in an impartial manner. So, I say that to tell you that when the clerk is offered, and I think the clerk is going to have to be offered as a witness, the whole allegation revolves around the contention that the clerk made contact with the jury about matters material to their verdict, that contact was improper, and that it impacted their verdict. There's a whole lot more that Mr. Harpootlian has indicated he'd like to explore that I regard as totally extraneous to the inquiry that we maintain. I'm not going to allow those questions to be asked by way of proffer and then have the clerk answer those questions and have that be the proffer, although I consider them irrelevant questions. We're not going to handle the case in that way. If I exclude a certain question from being asked, then the proffer will be whatever in writing is chosen to be offered in that regard. But I will not conduct a hearing where there's a whole side hearing in which every question desired is asked and either required to be answered or dealt with in some other way. I don't think that is an appropriate use of this very targeted hearing that I'm directed to have. I also think it makes a great deal of difference whether the questions that are being asked relate to the clerk's conduct at the time this case was tried, as opposed to other conduct at a later time or in connections with other things than the trial of this case. So I will be looking very carefully before we conduct this hearing and trying to give the parties as much advice as I can about what I would find to be acceptable topics to pursue. I think you're entitled to that, but I also think the record of the case is not to be used as a platform to explore each and every fault of each and every witness, whether it be the juror or the clerk. And I'm not going to have the hearing conducted in that manner. I think there are other ways of preserving topics that I rule should not be pursued than having those questions asked and answered, even though I ruled that they're not proper in the hearing. So I hope that explains kind of where I am on the subject of how questions are asked.
Interesting. Very interesting. I think she's pretty clear. No nonsense.
Therefore, some of the suggestions that are made in the filings you've made with me about the additional witnesses you'd like to call and subpoenas, I think we need to be sure we're all on the same page about what is acceptable in evidence and what is not. But I can tell you that I would not allow the subpoenaing and examination of attorneys in this case, of the judge who heard the case, or any of those type of witnesses.
So obviously one of the things that she's talking about is the defense's motion had mentioned bringing Eric Bland in, who is the host of Cup of Justice podcast with Mandy Matney and another person, I can't remember her name. But and he had made comments about Justice Toal prior to this, and there's a whole other issue, but they try to rope him into this too. So it's interesting. So they're trying to obviously bring the judge in and everything. So now she's finally addressing this, but let me get back to her.
The case is very focused on the jurors and the clerk of court, as I see it. Jurors and the clerk of court.
I'll rewind it, but yes, that's what she said.
Or any of those type of witnesses. This case is very focused on the jurors and the clerk of court, as I see it. Now, It's about 11, 15, close to it. I'm going to do this. I'm going to take a break for a minute. Let's take until 11:25 as a break. And in that time, I would hope that you formulate the other things you think we need to look at by way of the specifics of how this matter is to be conducted. I will then do two things. When I come back, and ask you for further ideas, both sides, as to who should be called, get very specific about who can be called and who cannot, who should offer these witnesses. And I would also at that time ask those who represent potential witnesses in this matter to come forward and have a conversation with me about your position on behalf of your clients. I think that's particularly
Probably referring to Eric Bland.
as we have the actual hearing itself. I've never heard of a situation where a witness can have their lawyer actively participate in the examination of the witness in a proceeding.
She's referring to
where
Eric
the
Bland.
witness is being offered. So I would not allow that, but I think we can protect the legal positions that attorneys for witnesses want to take and need to take and want to put on the record by pursuing in the way I've just outlined, and I'll be prepared to do that when we return. All right, court will be in recess.
Court will be in recess. They're like, you're coming with us. Gonna come up. You know that he's got to love the attention. You know that Alec has got to just love the attention that he's getting here, which is interesting. We got to kind of hear what they're saying. All right, I'm going to pause that, and I'm going to jump forward because I'm a couple minutes behind because I keep skipping to it. So interesting. So a couple things. Obviously, for Judge Toal, this doesn't sound like this. Sounds like she's wavering a little bit. Now, obviously, they're still going to have the hearings, which will give us plenty of fodder to talk about on this show. But we will. They're going to have the hearings, which is great. But it sounds interesting. Yes, and you're saying that, Lori, yes, he's a narcissist. There's also a study, which I want to do about solitary confinement, which is, it has been studied that people who are in solitary confinement act out because they want the attention and the human connection. So as being an inmate that's stuck into a box, that's stuck in a prison cell, obviously, like, he was a lawyer who was very much a part of the court system, and him having contact of any sort seems to, he seems to relish in that. That's just human nature. Still a horrible person, as we all know. But it seems interesting. We'll see what she says. I mean, let's not forget, we're all here because of this stupid book. Literally, this has caused all these problems. And there's going to be more hearings and more taxpayers' dollars. Very interesting that they're going to, obviously the defense throws everything at the wall. And I'm going to grab my coffee downstairs because it's not early. I've been up forever. I just literally was going to try to find this to broadcast to you guys, but I couldn't find the channel until very late. So apologies that I was not 100% on that this morning. I'll be way on it more coming up if we get to those hearings with Judge Toal. If you are new to the channel, I'm Collier Landry. Let's get into it.
Testimony continued today in the most notorious criminal trial in...
When I was 12 years old, my testimony sent my father to prison for murdering my mother. I decided at an early age that our trauma should not be what defines us. It's what we choose to do with it that does. I'm here to share my unique perspective on true crime, mental health, society, and popular culture, albeit with a slight sense of humor. I'm Collier Landry, and welcome to my show. And now you guys got to see my camouflage sweatpants, which I was like, oh man, I'm going to play that. I'm going to come back and then they're going to see me in my sweatpants. At least I had sweatpants on. I didn't start the show with the intro because I just got right into it because I found it and I was like, boom, let's get into it. But the court is taking a recess. We will obviously be back. They said 11:25, so I'm in Los Angeles. It's 8:20, so in 5 minutes. Sorry, I have asthma. It's the morning. It's when it affects me. Good morning, everybody. Anybody watched football last night? Tampa Bay Buccaneers beat the Philadelphia Eagles. I'm from Philadelphia. I was born in Philadelphia. I'm from Ohio. But I couldn't be happier because you know why? Baker Mayfield is the quarterback for the Tampa Bay Buccaneers, and he played awesome. So as someone who thought he was really treated poorly by the Cleveland Browns when they sent him out packing, I'm so glad that he had an amazing game, and they won the first playoff game. Literally, he had Tom Brady numbers, and he's not Tom Brady, obviously. But I thought that was great. Buffalo Bills won. It was an interesting weekend for football. It was an interesting weekend for football. So while we wait for this, I'm going to pull up. Oh, there it is. I already have it up. I tried to add it while they were talking. This is the now since they modified this brief that they filed a little bit. But one of the things that, and I'm going to pull this up here where I can actually see it. Okay, so sorry guys. I'm also going to react. Oh my goodness, computer. I'm also going to do a reaction to all of this later. There we go. So on page, and I broke through this all. So juror 630, and they address why juror 630, which they kept talking about. Which is these people they have these affidavits from. This is on page 7 of this document. 6, 7. There we go. So on page 7, juror 630 lists all exhibits you plan to introduce during the evidentiary hearing. Recorded interviews with SLED of jurors 254 and 741 and Rodham McLevin. It is impossible to specifically list all exhibits to be used in cross-examination of Ms. Hill. So it sounded like Judge Toal was not amenable to roasting, using the hearing to roast Becky Hill. And apparently she's going to, when they come back, allow some of these attorneys to speak who represent, no worries, court. Get to your job, please. Actual job interfering. It's all good. The state misstates the controlling legal standard and provides no authority supporting its mistaken position. In response to Mr. Murdaugh's motion for a new trial, the state incorrectly asserts Murdaugh must show both the alleged improper communication occurred, that the jurors were actually biased as a result. So that's what the judge, at the start of this, before I was broadcasting it, was discussing, Judge Toal was referring to past case law, saying, I don't see how this affected. It has to affect their outcome. If they had said, look, I would have given a different verdict. I was going to give a different verdict until Miss Hill's comments swayed me. And that's sort of the crux of the defense's argument as well. So, and yes, I agree, Lori. It is good to see that yes, absolutely, Court McNeil. Yes, she is. Yes, good to see the judge is controlling this so it isn't a circus. Yes, because it could completely, as these things do, as these things have in the Murdaugh saga, they have all turned into circuses. They're almost probably back. 11:25. It is almost. Yep, here we go. Maybe. I guess I could have replayed some of this part. Still waiting. I want to get to. All right. So I think they are going to be counsel for non-parties. So this is page 27. This is what she last referred to right before she left. Counsel of non-parties. Right here on the bottom. Counsel for non-parties should not be permitted to participate in these proceedings. Attorney Eric Bland has requested to participate in these proceedings as counsel for certain jurors who may be called to testify as witnesses. Here we go. There's no sound yet, by the way. So those of you thinking there's no sound, there is no sound. They have not turned the sound on in the courtroom. Thank you to the mods. Thank you so much. People asked why I had so many mods on my channel, and it had to be explained that we had some trolls interfering in our in our little community here. Oh, that person has a sparkly, fun shirt on. Or there could be a whole show if you were to watch people in the gallery of courtroom proceedings. You could judge their outfits. I like the guy's green tie. I like that green tie situation happening. I had to wear a tie this weekend. My friends got married, and I had to dress in grown-up clothes. It was it was an experience. I remember I used to like dressing up. And I was not pleased. Oh, is that Kenny Kinsey? That's Kenny Kinsey. I think. Yep, maybe. Yeah, to the left, maybe. No. Thank you, mods. Yes. What was I saying? Yeah, I had to wear a tie. I had to wear grown-up clothes. It was a thing. No, that's not him. Lawyer Lori was in the courtroom. Lawyer Lori was in the courtroom. Of course she was. This is quite a nice courtroom. It has like a little gallery or it's like a stadium seating. It's kind of nice. It's kind of nice. It's only 5 degrees Fahrenheit in Canada, in Alberta. It's only 5 degrees. The balmy weather is upon you. Time to break out the swimsuits and go to the pool. I don't even know what I would do. I get grouchy with it being 40 degrees here in Los Angeles. We are under, it's 50 degrees right now. We are under severe weather warnings. And it is supposed to rain on Saturday, Sunday, and Monday now, which does not make me happy either. Not a fan. This is an appellate court in Richland, South Carolina. Yes, I know. Richland County Courthouse. Richland County Administrative Courthouse, I believe. Karen, I was just about to say that too. I thought I saw a lawyer Lori, who's not a friend of Neil Gordon. So it sounds like we will be back in court with this on the 29th, as promised. Yes, we do, Court McNeil. Oh my goodness, I keep trying to post these comments. Yes, we have great team of moderators. Finally made it to double digits yesterday. That's fantastic. Did anybody watch football this weekend? Green Bay Packers on Sunday embarrassed the Dallas Cowboys. For those of you that are Dallas Cowboys fans, it's easy to bag on the Cowboys because they're no shows in the postseason, but I really genuinely felt bad for anyone who was a Cowboys fan. I didn't think they were going to lose to the Green Bay Packers. They got dismantled. It was embarrassing. It was the most embarrassing loss I think that team has ever suffered, ever. At least in my lifetime. It was insane. And they got dismantled by the Green Bay Packers, and it was horrific. I felt so bad for anyone who was a Packers fan because it was something else, that's for sure. It was something else. $20 will be in the mail. What's going on here? I'm in Edmonton, Alberta. Yes. Maybe we'll get back to the hearing. Judge Toal, you're late. You said 11:25. Maybe she said 11:45. I thought she said 11:25, which I thought was weird. They were taking like a little 10-minute respite. Might be longer. It might be longer. So for those of you joining right now, this is we are waiting for the judge to return to the courtroom. Oh, I don't know why that enter key does not work. For anyone who is curious, but I might leave this on the full screen layout and go get myself more coffee and let you guys chat amongst yourselves. I'm actually going to do a little experimentation here. We'll see if I can get Collier. What is he trying to do? This is a retrial, a preliminary hearing over the handling of what will be the retrial hearings that Judge Toal will be presiding over later on this month. It's a status hearing to determine who will take the witness stand when she hears the arguments that Murdaugh deserves a new trial. So that's what this is all about. This is why we are here. And the defense has submitted a brief wanting to call a bunch of witnesses and use sworn statements. There's also, so are they going to actually bring in these jurors who gave affidavits and sworn statements, or are they going to allow them to keep their anonymity? And are they going to allow Becky Hill to come in? Yes, go take a break. We can watch out for the return. Where were you going, Sarah Lynette? I was going to say you could always put it on your phone and drive, but that's not a good We should not be condoning watching YouTube and driving. Sorry, bad call here. Bad call here. He originally got 2 life sentences to serve, I think, back to back and not concurrently. I mean, he's already serving, he's serving time for pleading guilty to the financial fraud cases and the federal case and all that stuff. So if he was, oh, here we go. He's back. He's back, everyone. We'll get the sound up in a second as soon as it allows. There he is. The fact that my father has been in prison for 30 years is insane to me. It's no way to live to be stupid and greedy. Richland County. Sarah Lynette, you could have been there in person. I have the music. I think my alarm is going off playing music. Here we go. Here we go. Judge Toal. There we go.
Before we proceed further, a few other things that you've asked about that I want to clarify before we then go forward with a more specific look at how witnesses will be questioned.
Good morning, Thunder Road Queen.
First of all, how the jurors
Absolutely,
will be
Deborah.
questioned. Everything will be done in open court. The jurors will be referred to by number. The court TV cameras, which are the ones used to film these proceedings, will not be allowed to focus on the image of the jurors as witnesses. And if there's some need to further obscure the way they are presented, we can talk about that. But they'll be examined right here in the courtroom as other witnesses would be. And I've kind of looked at a little bit of exchange we'll have with attorneys for jurors to see what we can work out about exactly how the jurors are presented. But everything will be on the record here in open court with measures taken to ensure the privacy of the jurors. No photographs would be permitted of the jurors or anything of that nature.
So essentially, she's ruling on the fact that this is in their motions that they filed to keep the jurors anonymous. They're not going to allow them to be on camera. They're not going to allow photographs to take them. This actually happened in my father's trial too. There was a witness who had been stalked by my father, and he was afraid, and they did not allow photos or video of her to be be taken at all. So if you were in the court, you saw her, and if not, you never saw her. Which was, they do this for people's protection, which is a good thing, right?
And I believe if I announce that in advance, the press that are present, the press that have covered this proceeding throughout have been respectful of the judge's request, and I'm very confident they will be in this matter as well. With respect to the alternate jurors, I will question only the jurors who sat and considered this case. So the alternate who was dismissed by the trial judge. That alternate did not participate in any way in the deliberations about this case. There's nothing that's been brought to my attention about anything the alternate might have done that was improper at all in terms of communications with fellow jurors. Nothing's been alleged in that regard. So our focus will be on the jurors that heard this case. and not on either that alternate or any other alternate juror that has been proposed for questioning. I will not permit that. With witnesses or testimony I do not allow, let me explain about proffer. Proffer will be a written proffer by the party dissatisfied with the limitations of my ruling. But there will not be some examination as to proffer. The proffer will be a written proffer by the attorneys in accordance with their positions about witnesses and testimony. With regard to the subpoenaing of witnesses, the parties should subpoena these witnesses, and when it comes to the jurors, I would urge that the parties, the state and defendant, jointly deal with the issue of subpoena of these witnesses. I do not think it is the court's place to subpoena witnesses or order witnesses' appearances. This case is driven by the parties and their positions. The initial position of defense was that only certain jurors should be called. The state said no jurors should be called, but if you do, all should be called. All who sat on the case should be called. If the parties can't agree on how that subpoena should be accomplished, then I'm sure they'll let me know, and I'll try to take some measures in that regard. The concept I would have is that the jurors would report to a place that I will specify, and that when they report, they would be taken to a room with appropriate supervision by court personnel, and then called individually to recite their testimony. And then when their testimony was complete, they would simply take their place in the jury box until all were questioned. And then if there were any questions further by me that would be collectively made to the jury, I could do that. And if there are any further questions that were submitted to me by the parties that I chose to question, I would do that. And then when all of that was complete, the jurors would be allowed to be dismissed. So that is how I would handle the juror witness portion of this. And of course, I know I'm going to get some commentary from each side about that, and that's why I talk about this in advance. The other witness that surely needs to be called because of the allegations made is the clerk of court. The state has submitted a preliminary affidavit by the clerk of court, and the defense has many areas that they want to explore for the court. Again, I would like for the parties to develop some joint way of subpoenaing the clerk of court. And if I need to be a part of that, then I'm sure the parties will let me know. But I say this for the benefit, particularly of the attorney for the clerk of court, to know that I would expect that the clerk of court will be called as a witness in these proceedings, 29, 30, and 30 when necessary. We'll be using the same courtroom for these proceedings, this courtroom. And 3B will be used as an overflow for the press. Excuse me, 3A is the one over here, and that's the one I'll be using to conduct the hearing. This courtroom we're sitting in now will be an overflow courtroom for press with I'm sure, a court TV monitor that's available for them to monitor the proceedings if there's not enough room. Based on the attendance today, it might be plenty of room. We'll see. We'll have this as, I will try to figure out a way to be sure that the broadcast in here of the proceedings will not interfere with the conduct of the hearing past this partition next door. I will trust Mr. Bender to work with the press to arrange the courtroom and the overflow room in accordance with the rules I will set forth here and anything else that may come up that needs my attention. I think that covers it at the present time. So, well, the first thing I'd like to do is to get some clarity from the attorneys as to what furthermore, for the parties, as to what furthermore needs to be discussed. And then after that, we'll explore with the attorneys for the jurors and the attorney for Clerk Hill any other issues that still need to be developed. Mr. Hopwood.
Please support, Your Honor. I'm trying to make sure I understand what you just ruled. Are you ruling that we cannot call the alternate juror or the so-called egg lady to corroborate what was said to the sitting juror, since they were all told this at the same time?
I'm not sure I understand your question, but I'm just telling you that I want these jurors, these alternates would be called apparently to testify as to what the clerk said.
Yes.
At the present time, I see no necessity for them to be called to say what the clerk said, because we're talking about what the clerk said to the remaining jurors, those who actually sat on the case. The corroboration is something I don't think I need at this time. I think I'm perfectly capable of evaluating what the jurors tell me, and I'll do that. I think I'm also perfectly capable of evaluating the credibility of Ms. Hill and the jurors for that matter.
Well, Your Honor, for us to, and then you said you wouldn't allow a proffer of that except in writing. Now,
yes, I'm not going to have a courtroom proffer of any kind. If you want to proffer,
She is no nonsense.
what would be offered by means of affidavits, copies of emails, anything else you want to, that's fine. But I am not going to have a courtroom proffer. No. I think the only reason for the proffer would be to preserve your right to appeal. I believe your right to appeal my rulings will be perfectly preserved, frankly, even if you didn't have a proffer, but even more so if you supply an in-writing proffer.
well, I'm trying to determine whether an affidavit is sufficient for an appellate court, federal or state, when the state won't have an opportunity to examine that witness. But I mean, they've given, I mean, we can get more detailed affidavits, you know, these people are witnesses to what the clerk said to the juror who deliberated. I don't understand how that can't be relevant to Your Honor's decision. I understand there's two steps. One, did she make the statement? And two, was it prejudicial? These witnesses corroborate she made the statement.
Well, of course, that's what you say. So far, I haven't seen any of that. If that's what you say and you offer it to me in some form that I can evaluate it, I may revisit that decision. At the present time, but at the present time, I see nothing that prompts me to think I need to have people who did not sit on the case talk about what they think the clerk said to other people, when I've got to direct people to who it said that I will question.
There you go.
Well, Your Honor, we did submit an affidavit, but I have no problem going back.
You submitted one alternate affidavit,
right,
and one affidavit of a dismissed alternate. I'm aware of that.
Right. So.
And that doesn't prompt me to change what I just said to you.
All right, we can get you more specific. I understand what the questions are you have, and I would only put those folks up to deal with those very limited issues that you described. Put them up in 10 minutes.
Well, again, I'm not going to rule in a vacuum. I'll see what you say, and I'll rule upon it.
We'll get affidavits and file them with the court.
Very good.
Thank you.
Your Honor, just one issue as to logistics. Obviously, these jurors are down in Colleton County, and we're up here in Richland County. I've spoken with SLED, and in as much as we need, there may be jurors who need transport. SLED has certainly agreed to have 12 cars if we need to make sure that they're individual. They can then come in through the garage, and obviously they'll be brought up to a jury room. I think Your Honor indicated they can be in a jury room with a bailiff in there to make sure that no one's talking about their testimony and that sort of thing, but also so that they don't have to come in through the public entrance and that sort of thing. So that would be.
I think that would be a good solution, and of course, to satisfy the concerns that the defense may have, you could either have a member of the defense team or one of their employees ride with them, or if you could agree upon a sworn statement by the agent or person that does drive them that they A, will not say anything, and B, did not say anything, then that may cure the problem too. I think you all can work that out. But I do think having proper transport would, first of all, be a comfort to the witnesses themselves, the jurors themselves. But if they can arrange something otherwise, of course, they'd be free to do that. But to the extent it's a burden on them, yes, I think that's a good idea. And in all events, I would want arrangements to be made to have the jurors come to the parking garage in this building and be escorted up in a private way into their assembly room.
And yeah, absolutely, Your Honor, and we will, and I'm sure SLED, I've already spoken with them about that, have uninvolved agents who will be under strict instructions not to discuss the case, and happy to have them sign affidavits or whatever to that.
Very good. All right, anything further before I go to the lawyers for the jurors? All right.
Your Honor, only one other point, and that is you asked us to give you exhibits that we would use.
Yes, sir.
Having not asked or had the opportunity to ask Ms. Hill a single question, I can't tell you, and in terms of, there's not thousands of emails we've used, probably 5.
I'm just going on some of the descriptions that were in the filings y'all have made to me.
Well, we've received thousands of emails from Colleton County based on a subpoena we issued. We've received hundreds of pages from the AG's office and from SLED.
It'll make it a lot simpler if it's a small number and a discrete number submitting them to me. Again, I told you I would evaluate that when I did it.
Of course, I don't think you can evaluate them until she testifies. You don't
Well, I think you're going to have to trust that I am going to do some evaluating before she testifies.
Okay, and Your Honor, she's given an affidavit denying making any of these statements.
She has.
So these alternate jurors that have been dismissed, would you allow us to call them to impeach her if that's what she testifies to?
At the present time, the answer to that is no, as I have indicated. But again, I'm not going to rule in the vacuum. I would hope that what you all will do is send me a pretty specific idea of what you want and how you want me to permit it. So I'm not going to rule on something I haven't seen yet, which is your proposal as to exactly how these witnesses and alternates to be used.
All right, we'll get more extensive affidavits from those two alternates.
Oh, okay. That's fine, or descriptors of some sort from you as to what you intend to do. I'm not going to dictate how you do it, but I'm going to have a lot more than just kind of the generalities that have been discussed in these briefs in order to permit some.
Well, I think we're going to need an affidavit for appellate purposes, nothing else. I mean, my description to you is not evidence.
Oh, I agree. But, again, I will tell you how I'm going to accept the proffer. What you put in the written proffer, is up to you. I don't want to dictate that or manage it.
Well, I just want to say that we're going to hopefully be able to get affidavits from these folks.
Yes.
Much more descriptive than the original affidavits.
Oh.
Thank you.
Yeah, she seems to be controlling her court quite well, and she's basically like, I'm not going to call him Poot. Mr. Harpootlian, you are not going to manipulate the situation. This woman is no nonsense.
Your Honor, may I consult with counsel very briefly?
Certainly.
things that was discussed earlier was the independent SLED investigation that was done. There were recordings of some of these interviews and MOIs prepared, and they were just meant to be summaries. I know Your Honor mentioned earlier that you would be open to receiving those. I just
I'd be glad to review any of that.
discussed that with counsel, and I believe they said, well, we want to send the ones we want to send. I think if Your Honor's amenable to that, we would just add Your Honor to the discovery upload that was provided to the defense so that that information is available to the court for whatever purposes the court deems necessary.
Can I ask this?
Yes, ma'am.
First, would that discovery upload include your interviews, the tape of the interviews, as well as your summary of them?
Yes, ma'am.
All right. I will ask you to let my clerk, either Diaz, talk with you afterwards about how to send me something of that volume.
Sure.
Our court, IT has a lot of barriers in our system to us receiving even conventional websites and web tools for examining in volume documents. And so I will want her to interact with you all about exactly how I am to receive that material. But yes, I would be happy to receive it.
And we would be happy to get a couple flash drives and provide it that way, if that makes sense.
That might be the better way to do it,
Yes,
because,
right.
again, I can very easily examine a flash drive, and it takes a long time, and typically you are kind enough to provide an index at the front of the flash drive as to where the various materials are located. That might be better than using one of these web document sources, since so many of them are excluded from our system.
All right. Well, we'll prepare one and have a copy for you, Your Honor, and then for Ms. Diaz, the clerk, as well. Thank you.
Now, on my list, I have in the courtroom at this time, Mr. Bland, who represents certain of the jurors.
Mr. Bland.
Mr. McCullough, who represents certain of the jurors. And Mr. Lewis, who represents Ms. Hill. Are there others in the courtroom who represent jurors or Ms. Hill?
Your Honor, Ronnie Richter, I'm Mary Claims partner.
Went a little fast for me.
Ronnie Richter.
Oh.
Mr. Claims partner.
Ronnie
Right.
Richter.
Any
Oh, boy.
others? All right. Well, then we'll begin with you, Mr. Bland, if you and Mr. Richter would come forward.
Here you go.
Ronnie and I represent 4 jurors who rendered verdicts in this case.
I would like their numbers, but only if that doesn't violate the attorney-client privilege. And you may give them to me now or later.
Can I give them to you later? I have them now. Our job is we want to preserve their anonymity.
I understand.
2, we want to make sure that they're not harassed. And 3, we want to make sure that the verdicts of their conscience remain. And that is not only because they voted guilty. If they voted not guilty, we would feel the same way. After hearing what Your Honor has established by the way of procedures, we're very comfortable with what you have established to protect their anonymity and that they're not harassed. Ronnie came up with a good suggestion. Maybe you renumber the jurors 1 through 12, and that way, because there has been some public disclosure of the jurors' numbers in some of those emails, they were the big batch of emails that just are hardly referenced. So maybe we cross-reference with the chart 1 through 12 and the juror numbers. But as far as the questioning goes, there's no need for us to be part of this. You're going to make the questions. You've indicated that you're going to preserve their anonymity, that they can't be photographed, they can't be on videotape, and that's about all we have to add.
Yeah, Your Honor, I would amplify that I certainly respect and appreciate the significance of the issues that are before you. And I respect your decision that you're going to make this public. I would have asked you to make the jury portion a closed courtroom. And Your Honor, only for this reason, that I don't know what the jury's going to say, I don't know what you're going to rule, but let's just say in a hypothetical setting that because juror number 9 said something that you believe deprived Mr. Murdaugh of his right to a fair trial, you're going to grant a fair trial, a new trial. I would hate for there to be any mechanism for somebody to backtrace to who was juror number 9 because I know the public has very firm opinions about this matter, and I wouldn't want that person to be subject to any kind of public scrutiny. So I would have asked of you that for the juror portion that would be closed courtroom, that the press would be present, that their likeness, both voice and face, be muddled, just as an additional safeguard. But I certainly appreciate the safeguards you have put in place. I respect your ruling. I just throw that out for consideration. And on a broader perspective, I know that you've had this experience as well, Your Honor. It's becoming more and more difficult in this state to see the jury. And I can't think of anything more injurious to jury service on a broader perspective than to see, jurors who've given up 6 weeks of their lives being pulled back in for a process like this, as necessary as it is. So I worry that the process be handled as gingerly as possible, so as not to further prejudice our ability to get juries going forward.
Thank you, sir. What I will do is this. I think your suggestion of renumbering is a good one. It's something that my clerk and I have talked about between the two of us as well. In every proceeding I've ever seen where a juror was questioned, in every case I've read where jurors were questioned because of allegations either during trial or post-trial that they had been tampered with, those proceedings have been in open court. And I don't feel it would be appropriate for me to have some kind of in-camera proceeding, even if it included the attorneys that would have to, and even if it included members of the press but not the general public. I don't think that is in keeping with the public nature of trials in this state and the public nature of court proceedings. However, I think we could make some protective arrangements for when they testify and their ability to be dismissed after they testify that would protect them from being set upon to the best extent possible. So that is the way I will handle it, and I hope all things on balance that is as protected as you think it needs to be.
We trust you, Your Honor.
All right.
Your Honor, on behalf of our clients, we will accept their service of the subpoena so that they don't have to do so.
Well, that's great, and of course you don't represent all of them.
No, our four.
You're for, but that's great, and it may very well be that these parties are going to be able to work out something with respect to some of the rest of them. I don't know, but I appreciate that on behalf of the ones you represent.
Do you want me to come up and tell you our juror numbers, or you want me to wait?
No, sir. You can. I don't need that at this moment.
Okay. Thank you.
Thank you, Judge.
Yes, sir.
Interesting.
Mr. McCullough.
Would you like me here or later?
Go to the podium if you would, please.
I believe by some of your rulings today, they've satisfied several of the things I was going to mention. One, Your Honor, was, of course...
How many jurors do you represent?
I'm sorry, Your Honor. I represent number 785 and 630. One is was a deliberating juror, I suppose we call her, and the other was the removed juror.
Right. Now, with respect to the replaced juror, I think my ruling about the end of any testimony from that juror satisfies any requirements you've made. I believe that I will not hear testimony from that juror, alternate juror at the present time. Now, Mr. Harpootman is going to submit additional information. As regards your client, I ask you to submit that information to me as well, and then I'll see if there's any revision of the position I take about that. You also represent one sitting juror, so you may continue.
Your Honor, the other juror was not an alternate. She was an actual seated juror.
That's right, the sitting juror.
Who was removed at the end of the trial.
Oh,
private deliberations. Whoops.
I need Mr. McCall to speak up, please.
You need to speak up some, Mr. McCullough.
I don't get that much, Your Honor.
Yes, sir.
Your Honor, if you'll indulge me just a moment, I think much of what you've said today bears on a quote that I'm taking from the response of the state, which was filed and is part of your record, and my letter of November 10th responding to that filing is also a part of your record. But the state said that jury duty is this cornerstone of civic duty. Needless exposures of jurors to litigative stress and impeachment by zealous attorneys in a case especially of this public exposure can only serve to discourage citizens from willingly participating in this civic duty. Your Honor, I'm delighted with your ruling that you'll be asking questions. I've been subject to your interrogative skills in my appearances before the Supreme Court. So I'm pleased with that, and I checked that off the list. I would like, Your Honor, for you to take judicial notice that there have been excessive public comments by, and I have to.
I love how he was doing a little bit of ass kissing there. That was hilarious. I don't know who this guy is, but yeah, interesting.
I say, Your Honor, in my letter of November 10th, I took Mr. Waters to sign the letter to task for labeling one of my clients, one of these jurors, as dishonest. I think I wasn't pleased with that. I think that discourages civic participation. I would ask the court to admonish the litigants, the attorneys.
Mr. McCullough, let me stop you there. I am not aware of any of what you're talking about in terms of comments about the jurors or otherwise. So that's just not something I'm going to take into account by listening to it or by taking any judicial notice of it. I don't know what I would be taking judicial notice of. I do not know anything about what you're talking about.
Well, Your Honor, both my letter and the response of the state are part of the record, which you obviously have not gotten to, but I would assume yet. My only request is I would admonish lawyers, officers of the court in this courtroom and outside of this courtroom who represent people to be cautioned that this is a search for the truth, not an effort to protect the verdict, nor an effort to discourage people from participation. A negative commentary does that, or runs the risk of doing that. That's all I'm saying.
I understand, and I decline to instruct or admonish participants in this procedure in any way about what you say.
Thank you. Your Honor, next, I like Mr. Richter and Mr. Bland appreciate your efforts. I suspect that we will decline a ride to the courthouse, but I would ask the court to consider allowing the jurors who choose not to ride with SLED agents to be permitted an entry and exit from the courthouse that would involve or relieve them of the necessity of coming through the front door.
I think I've already said that I will make arrangements for juror witnesses to report to the basement where the law enforcement station is, and they'll be appropriately directed to the assembly room.
And Your Honor, lastly, I think, if I understand your rulings or discussions about the process that will occur here, this may run at odds with it, and I'm not arguing with you, Your Honor, you know best. I am of the belief that this litigative stress that I earlier referenced could be avoided, and the public and the media not denied their opportunity to gain access and knowledge of the proceedings by not exposing these jurors to a crowded gallery, a full gallery of press, by allowing its recording through, I understand, court TV will be the pool camera. That is to say that I have actually, in my history, participated in proceedings that involved the questioning of jurors, which was done in camera. So I don't think it's without any precedent, but I would obviously respect your ruling, but I would ask you to consider or reconsider that no damage would be done to the right of the public to know and participate in the proceedings but you can accomplish the same thing by allowing the pool camera and avoid the distraction and the imposition of that on these jurors. And
I hear what you're saying. I'm not inclined to change the ruling I've made at the present time, but I'll keep an open mind about it as we make pre-trial preparations for the hearing. At the present time, the jurors will be examined in the courtroom, as I have indicated, with appropriate identity protection.
thank you, Your Honor. And subject to your rulings, I will have both of my clients available for these parties as they might be needed, subject to your subsequent rulings.
Thank you.
Thank you.
Your Honor, do you expect all jurors to be present for all 3 days?
So, let me make it very clear that I expect the jurors will be the first witnesses to be called in these proceedings. And the jurors will testify, and then they would be dismissed. They would not be required to stay for the rest of the proceedings at all. So that is very much a part of my thought about what it takes to protect their identities. They would be protected as best I can, and the ability of others to come and to set them with questions as they leave would be protected. So,
Do you expect that you could get through all 12 in one day, or should I tell them, because a couple have to take off of work?
yes, I do.
Okay, thank you.
All right. And Mr. Lewis.
Your Honor, I'll be brief. In light of your rulings, I don't think you need much from me. The only thing that I'll add is I'll have Ms. Hill available for here as the parties need them, and happy to accept service to alleviate one issue for this court.
Becky Hill's lawyer is the one with the fancy tie that I like. The green tie. Green! The color of money! What a surprise! Sorry.
All right. Thank you for that. And before you leave the podium, let me just consult with the lawyers. I'm not going to ask them to examine you. That wouldn't be fair at all. But I'm going to ask them if there's anything else I need to inquire of before I let you go. But as I understand it, the subpoena, and we would have a formal subpoena of Ms. Hill, would be placed in your hands as her attorney. And you would assure her appearance, and I appreciate that very much.
Absolutely.
Is there anything else on behalf of Mr. Murdaugh?
Your Honor, just in an effort to try to expedite this matter, I have two questions. One, will Ms. Hill meet with Mr. Griffin and I?
I'll evaluate that.
You'll evaluate it. Okay, that's all I can ask. And secondly, should we have her here on that Monday, or wait? I mean, if you're going to be doing the jurors most of all
She should
day.
be here as court begins.
All right. Thank you.
Nothing from the state, Your Honor.
All right.
Thank you, Your Honor.
I'll go over my checklist one more time, but I think I've covered everything I want to cover. I'll come to each of you in a moment.
I bet Becky's
Yes,
attorney is not pro bono either. I bet not pro bono either.
Would be jurors and Ms. Hill. So I want to be sure that we're all understanding exactly what's going on in that regard. I would not allow the attorneys to be called. I'm unclear about the mention in some of the papers that SLED investigators would be asked to testify, or any other witnesses. So I'm going to go one more time. I want to get real specific so you will understand what you need to prepare for by way of in-court examination and what you need to prepare for by way of submitting proper. All right. First of all, for the defendant.
Please, Court, Your Honor, just a couple of issues. One, we don't know who we're going to call to impeach Ms. Hill, because we don't know what she's going to say. So it's difficult for us. I mean, once she testifies, at that point, we say we'd like to call so and so and so and so and such and such and such and such. Number one. Or maybe no one. I mean, she may concede every issue we have. For instance, she did tell, according to the state, she did tell one of her assistants, one of the people helping her, you know, I hope he's found guilty because it'll help book sales. Now,
I hope that's the last time you're going to repeat that until I ask for it again, Mr. Harpootlian. I've told you that I can't imagine a situation in which I would go that far. So, a statement like that, and she may well have said it, if it goes to anything I'm asked to consider, it would be to her credibility. And I'll evaluate whether I think that's even proper to ask, but let's move on from that.
But there are other questions concerning her credibility.
Yes, sir.
404 motive. If she did this, it is a crime. And so, you know, the questions of why she would have done this extraordinary act, and we can argue this at another time, but in terms of me, the reason I mention it is for us to proffer those people now, not knowing what she may admit. That question may get asked, she may admit it. There's no witness that needs to be called. So it's difficult for me to game this out. I don't think I've ever been asked to list witnesses I would call to impeach somebody if they lie under oath. I've never heard of such a thing, but I will attempt to do the witnesses we would call prior to Ms. Hill's testimony. That's all I think I can do, if that makes sense.
It doesn't make complete sense to me because this is not the trial of Ms. Hill. And issues about motive and so forth and the possible commission of crimes are not what this inquiry is about. It is about her contacting any of the jurors and what she said. So I will be treading very carefully with a good deal of what you say about what you might or might not ask. But I am going to ask all the parties to be pretty specific with me about what I should be asking the jurors, and I can make a decision in advance as to what I am going to do about that, and what is going to be, at least by general topic, pursued with witnesses.
Yes, sir.
And the reason I do that is because it gives me the opportunity to then consider what rulings I would make and move the proceedings along in an orderly way.
Well, Your Honor, it may be premature for me to note this for the record, but we would accept your ruling on that.
All right.
Okay. Secondly, Mr. Murdaugh has been unable to review any of the discovered material in this case because of the confidentiality order prohibits us to distribute to him while he's in jail. We don't have time in the next less than 2 weeks to go sit down with him and review everything. Would Your Honor allow him to have them? And the materials are not as to the evidence in the underlying case, it's as to juror issues. And while he is no longer a lawyer, he was a lawyer at one point, and can evaluate this and be of assistance to us if he has an opportunity to review that material.
You're speaking to me about something in a complete vacuum as far as I'm concerned, so I can't really evaluate what you haven't been able to review with him and what you have been able to review with him. As I understand what you're telling me is I have received certain information as the attorney for defendant that I have not been able to show defendant for defendant's review because of the confidentiality order. I can't imagine that. I think what you may be saying is Mr. Murdaugh has not been able to keep for himself, while I'm not there, confidential materials.
That's correct.
That is something common to many folks who are under incarceration are limited in the kind of materials that they can receive and keep in their possession when they're not with their lawyer. This is not an issue where he's being deprived of the ability to consider material that you have received This is a question of whether he can have that material in his possession when you are not there, or your representatives are not there, and study upon it and so forth. I can't control what the limitations of the Department of Corrections are, nor can I control what limitations may have been put on confidential material because of the fear that it would fall into other hands. So I'm not going to rule in the abstract on things. I would have to have something that's pretty specific, but I can tell you this. I would certainly not order that these materials be wholesale given to him for him to take back to his cell and have in his possession, because I don't know who might see them were that the case. And if they are confidential materials, that would be an extreme risk of breaching the confidentiality of materials to do that because of his situation. And his situation is as it is, not my making or yours.
Your Honor, I would only note for the record this: much of the material we've received has been within the last 2 weeks. This hearing is scheduled for 2 weeks from yesterday.
Yes, sir.
And you've given us more stuff we have to do between now and that hearing. There's nobody to go sit with him at the jail, and his time is limited as to when those people can visit. So without him being able to review this material, I don't believe we can be effective, and we would be ineffective in representing him.
Well, I understand that those are wise statements for an attorney to make to preserve your position on the record. It doesn't change my view of how we should proceed in this matter at all. I think you will be able to, if there are deficits in what you have been able to do with your client, you will place those contentions on the record, and the appellate courts of the state will have an adequate chance to review them.
Well, Your Honor, would you consider continuing the hearing on the 29th to allow us to meet with the client and effectively review these materials?
No, sir.
Okay.
Thank you.
We respectfully accept your ruling.
I understand.
Thank you.
Mr. Waters?
I don't have much to address, Your Honor. The initial question that Your Honor asked was about SLED agents being listed on the potential witnesses. And, again, Your Honor, when these allegations were first raised, we instructed SLED to do an independent investigation, good, bad, or ugly. And only because of the results of that investigation, or the reason why we're standing here and litigating these issues before Your Honor, ultimately the only way that SLED agents could potentially be testifying, and again, when we filed our response, we didn't know exactly the parameters the court would rule. The only way, though, that I could see them potentially testifying is in the event that there is an accepted witness by Your Honor, that there was some sort of prior inconsistent statement under Rule 613 or some other permissible inquiry. But I think Your Honor's rulings as to the nature of the inquiry we're going to conduct would probably remove or make very unlikely that need.
All right. Anything further?
Nothing from the state, Your Honor.
Nothing to defend, Your Honor.
All right. I say to attorneys for both sides, the court is deeply grateful for the very fine materials you have submitted so far. This an extreme amount of work in a very truncated period of time, and I appreciate the burdens it places upon you. Mr. Hopkins, I particularly thank you as a member of the General Assembly for not interposing your immunity because you are in session, and I respect that. I set these matters after consultation with y'all so that I could fulfill my obligations to the court as expressed in Chief Justice Beatty's order. But I realize that I'm doing that with your extreme cooperation in light of your other duties, and I appreciate it very much.
Thank you, Your Honor.
I look forward to further submissions from the parties and from the hearings commencing January the 29th. Court will be in recess.
Thank you.
Thank you, Your Honor.
I asked Ms. Harris before these matters commenced to please expedite, even if it's in a rough form and not in a perfect form, the court would like to produce their transcript. transcript. I asked her to produce a rough copy of the transcript just as soon as she possibly could for both sides. I hope you all will consider, without me having to order, sharing the expense of this production, this early production of the rough copy of this map. She will be in touch with you. You may be in touch with her with regard to the rough transcript of these proceedings. We'll be in recess.
Thank you, Your Honor.
And there you have it. There you have it, kids. I will be back later today with a full analysis of all this, breaking down what happened. Because we were late to the game to get started, late to the party. And back he goes, yes. Yes, whatever book sales she's made is going to go to the lawyers. Absolutely. And Judge Toal is not messing around. I agree 100%, Adelaide. Follow the rules, Poot. I realize I'm looking to the left, but the comments are on the right. I don't know how I can fix that. It's really annoying. Maddie Soul is barking, everyone. She's like, why am I not going outside, Daddy? Hi, lovely mujercitos. There he is. Back in his hole he goes. Back he goes. You know, if anyone who's ever been handcuffed in a non-fun way, it is not fun. It is not fun. And who do we have in courtroom? I think that's the girl, the blonde girl. I think that's the one that works for Fitz News. I don't know who that dude is. Oh no, maybe not. Kind of looks like a girl I went to high school with. Enjoy a crappy. What is the new vocabulary word for the day? This afternoon, Collier?
My name is James Christopher Wilkes.
Nope. We are. Hold on. We are going to. Nope. We remove that. Bye. Stop screen. Remove from studio. Great. What is the new word of the day? The new word of the day is prevaricative, even though it's not really a new. Even though it's not a new. Surviving the Survivor wants to have me on chit-chatting tomorrow. It is prevaricative would be the word of the day. Prevaricative. I've used that term before. It means to be evasive or evade questioning or kind of beat around the bush, if you will. It's a very fancy way of saying people are being evasive. I think that we saw that with Dick Harpootlian in this Harpootlian in this particular hearing. He was being a bit prevaricative with the judge. Yes, Joel. Can do that. Surviving the Survivor is great. Telling I'm live right now. read your text message, Joel. Gen X Granny. Gen X Granny says hi. Oy vey. Yeah, so I will be back later on today. Yeah, I was one of Joel. If you guys don't know, I was one of Joel's first guests on his show a couple years ago. Yeah, a couple years ago now, 2022. When he was just starting his YouTube channel. Yes, Joel and Carm are great. Carm. I remember when I met Carm in person not too long ago at CrimeCon. LASIK update. My left eye, which is supposed to be the far-sighted eye, is not seeing far yet. But I noticed something. I used to use eye drops and rub my eyes all the time when I was wearing glasses, and now since I've gotten the LASIK, I'm not doing that as much. Everybody said your eyes are going to be drier. I feel like my eyes are better and less dry because there's less strain. Hi, the party has arrived, Mover Nation. Welcome, Tina Luffman. So I'm going to put up a live for later today where I'm going to chit-chat about all this stuff. Maybe we'll do that. Let's see. All right. Let's go over. Your first live. Well, thank you. But this live is getting ready to end. I'm so sorry, Rosemary Lemony. But there's going to be another one. I'm going to do it right now. Oh, good. Looking forward to that. Okay. So we'll do a little analysis. Tell her I send my love, says Joel Waldman. Gen X Granny. There you go. Awesome. Tell her I send my love. So I guess I better put that in the calendar before I forget. Which means I might start streaming it on my channel. Classy word for lying. Prevaricative. Yes, it can also mean to be evasive. That's how I often use it when you're trying to corner someone. That's so great, Gen X Granny. I just made it to gonna have to stay on another 5 hours, pal. Hello, Shago guitarist. Hi, Nina Sage. That's okay, LL. Story of my life. It's all good. But, all right. I'm going to set up another live. I'm going to do a little mashup of this thing that we just watched. 3 hours. And we'll go from there. I said the court was in recess. Was court in recess or court adjourned? Are they coming back? I missed that part. I totally missed that part. Just finished work. We'll catch the next one for sure. Day off tomorrow. Hurrah. Oh, fabulous. Hello, Sharon. Time to go, Papa. Yes. Marisol is like, you need to go outside. Hey! She's an angry one. Yeah, let's yeah, she does need to go potty for sure. Let's see here. Murdaugh. Ah, the other doggy was going outside, so that's why she was barking. Sorry, guys, I'm setting up our live for later today. We will have a full reaction and update to all of this. At 3 p.m. Is that what we want to do? 3 p.m.? How does that sound, guys? 3 p.m.? 3 p.m.? Should we schedule for 3 p.m.? Can you give us a little ditty on your guitar someday? Yes, I will. Movers merch. Fabuloso. I just watched your panel discussion after Murder Mansfield. Oh, thank you so much. Marisol needs to go potty. Yes, she does. Collier, please make sure you bring the Becky Hill book with the 10,000 sticky notes. Yes, I will bring out the Becky. I'll try to make a reminder. That's what Google says. You should do a word of the day, one day of your live. Yes, I need to do that. We have Court McNeil on it. 3 p.m., which is Pacific time, so 6 p.m. Eastern time. So in 5.5 hours. Yes, I think we'll do that. Let's see. View on YouTube. And I'm going to put the link to that right here in StreamYard. God, I feel so efficient. Here we go. You will be able to see that video right there when we live stream today, Tuesday, 6 p.m. Eastern time. Full analysis and reaction. Reaction to today's hearing. There you go. You have the link. There it is. Booyah. And I will see everyone very soon. I will see everyone in 5 hours and 20 minutes. I think I can get to the gym between now and then and cut up some videos and finish some other projects I'm working on. Yeah, we got time. Let's do it. Let's do it. Mover Nation. I'll see y'all a little later. Peace. And yeah, I'll get into my little end. Thank you all for watching, listening. Wherever you may be, and however you may be listening or watching, thanks for making me part of your day. And thank you to all my channel members, channel subscribers, Patreon supporters. I will see y'all on the next one here in 5 hours and 21 minutes. I'm Collier Landry. See you on the next one.
This podcast is made possible by support from listeners just like you. For exclusive content around this podcast, please consider supporting me via Patreon by going to collierlandry.com/support. Please subscribe via Apple Podcasts or wherever you get your podcasts from, and please leave us a 5-star review. If you want to see video episodes of this podcast, please check out my YouTube channel at youtube.com/collierlandry. You can find links to additional resources in the show notes of today's episode. This podcast is a production of Don't Touch My Radio. Copyright Collier Landry.